Rivers State Governor Siminalayi Fubara has insisted that his administration will not recognize the State House of Assembly led by Martin Amaewhule, despite mounting pressure from the Rivers National Assembly Caucus. The caucus, during a solidarity visit to Amaewhule in Port Harcourt on Monday, urged Fubara to execute the Court of Appeal judgment that affirmed Amaewhule and the 26 lawmakers as the only legitimate members of the Rivers State House of Assembly. In a statement signed by Kingsley Chinda, Obiakpo Federal Constituency, Senator Barinada Mpigi, Rivers Southeast, and Dumnamene Deko, Kana Gokana Federal Constituency, the lawmakers expressed dismay over what they call the governor's deliberate distortion of facts and court judgments. The statement accused Fubara of engaging senior advocates, including Femi Falana, to misrepresent judicial rulings. They allege that Falana lied about the ruling of Justice J.K. Omotosho and the purported defection of the 27 lawmakers, which they claim never happened. They also said that Falana lied about the dates of the judgment of Justice J.K. Omotosho with the intention of misleading the public. The caucus warned that failing to implement the judgment will amount to contempt of court. They further accused Fubara of interfering in legislative affairs and questioned the legitimacy of his recent appointments. Speaker Amaewhule declared that all those parading themselves as commissioners, permanent secretaries, and civil servants are impostors, as they have been screened and confirmed as they have not been screened and confirmed by the assembly. He also warned that the governor's handling of the state funds will soon come under scrutiny. He said, the governor should know that we are not sleeping. We are aware of the hundreds of billions of taxpayers' monies that are missing today. They are not accounted for. A day of reckoning will come, Amaewhule stated. However, in a swift reaction, Rivers State Commissioner for Information and Communication, Joseph Johnson, dismissed the lawmakers' claims as misleading. In a statement titled Setting the Record Straight on the Situation in Rivers, Johnson insisted that Amaewhule and his faction ceased to be lawmakers after defecting from the People's Democratic Party to the All Progressive Congress on December 11, 2023. The judgment of Justice Omotosho, which was affirmed by the Court of Appeal, does not touch nor alter the status of Martin Amaewhule and his group of 27 as ex-members of the House of Assembly of Rivers State, Johnson said. He argued that their defection automatically resulted in the forfeiture of their seats. Right Honorable Martin Amaewhule and 26 others lost their seats in the Rivers State House of Assembly following their voluntary defection or cross-carpeting, which happened on the floor of the House of Assembly in the full glare of the public on December 11, 2023, Johnson said. Johnson further emphasized that Governor Fubara remained law-abiding and had no intention of recognizing individuals who no longer hold legislative office. The Governor of Rivers State, His Excellency Siminalayi Fubara, is both law-abiding and peace-loving, and accordingly has great respect for the court of law and the Nigerian judiciary. The Governor swore on May 29, 2023, to defend the Constitution of the Federal Republic of Nigeria and the rule of law, which includes respect for courts, Johnson stated. Ndamzi, what do you have to say about this development?
Yes, thank you very much. I will begin by saying that it is very, very wrong. We have insisted on, rule of law in this country, and we cannot have rule of law when people in positions of trust and authorities does not obey the law itself. At that point, one would wonder what the society would become. And believe me, we have children learning. They are learning from the ways of our leaders. If the leaders are not, dispensing justice properly, it will set bad records in the minds of the growing folks. So I would rather advise the governor, like we had maintained on several occasions, that he should recognize Martins and the 26 members of the House of Assembly, because the court have reaffirmed that position. There have not been a contrary, declaration to that effect by any superior court of record. So, repeatedly we have said, obey the laws, recognize the assembly, and let there be peace in the state. Because everybody wants peace in this state. If Rivers State enjoys lasting peace, there will be more development, there will be more projects, and all that. And then I would like to add a voice on the paragraph that talked about the legitimacy or otherwise of the appointees.
Let me quote what the Commissioner for Information said, so because I would actually love you to react directly to that. He said, the judgment of Justice Omotosho, which was affirmed by the Court of Appeal, does not touch nor alter the status of Martin Amaewhule and his group of 27 as ex-members of the House of Assembly of Rivers State.
Yes, but Honorable Johnson Joe shouldn't forget that the Court of Appeal in that judgment recognized Martins as the Speaker of the Rivers State House of Assembly. So, if the court doesn't recognize Martins as a member of the House, how then did the court, re-echoed the fact that Martins remains the authentic Speaker of the House? So you cannot approbate and at the same time you are reprobating. We should set this record straight. People in authority should learn how to obey the law. Nobody is bigger than the law in this country. The law is so big, and the law is bigger than everyone. So, both high and mighty is subject to the tenets of the Constitution. And there have been a proper court judgment from an appellate court. I mean, disregard to that judgment is really so worrisome. We need to check it in this country.
Well, now, to a large extent, you're of the opinion that the appeal court upheld the speakership of Martin Amaewhule.
Yes.
Direct question. In the judgment of Justice Omotosho, did it recognize Martin Amaewhule as the legitimate Speaker of Rivers State House of Assembly?
Yes, of course. In that judgment, Justice Omotosho said Rivers State House of Assembly does not have two speakers. That Martins remains the authentic and only one speaker of the House. So what the Court of Appeal did was to uphold the judgment in its entirety. That's exactly what the Court of Appeal did. The judgment is in the public space. People can access these files and read through. The pronouncements of courts were direct and never vague. So what's happening in Rivers State is just, a government not wanting to obey the court's judgment. And to me, it is very wrong. It is setting bad precedent. It is setting our state backward, because we need all the dramatists personnel to come together and move the state forward. If this division and infighting continues, we cannot have it. We cannot have the best of project funding. We cannot have the best of project execution. We cannot even, dispense other policies very well. Policies of government cannot run well because there are infighting. So the infighting has lasted so long, and it is uncalled for. So we are calling on His Excellency Sir Siminalayi Fubara to shield down his sword, recognize the assembly members, and let's have peace in the state.
Now, to a large extent, there have been controversy over the dismissal of the Supreme Court, the dismissal of the appeal of the governor at the Supreme Court, because the governor's camp requested for withdrawal of that matter. Now, the question I want to ask is, what is the implication of that dismissal by the Supreme Court?
It is very clear. The law is very clear. There are, in the judiciary, there are hierarchy of courts. Okay? Since we have hierarchy of courts, we also have hierarchy of judgments emanating from those courts. Okay, now, the Court of Appeal, in that judgment, in that ruling, gave judgment in favor of the adverse party. Now, the Rivers State government appealed that judgment to the Supreme Court. If I approach a court for a pronouncement or an order or further orders, as the case may be, and at some point, I go back to same court and withdraw my application, what I am invariably telling the court is that I am no more fighting, I accept what the lower court have said. So, Rivers State government withdrawing its matter in Supreme Court led to Supreme Court dismissing that suit. The implication simply means that the Court of Appeal judgment is the law. So, we, in my view as a lawyer, with due respect to the learned seniors out there, I don't care what anybody might interpret, but what I know is what I was taught in law school.
Okay.
Yes, that we have hierarchy of courts, and we have pronouncements coming from those courts remains the law until otherwise, until a higher court of record pronounces otherwise. So since we do not have any pronouncement from Supreme Court regarding that particular Court of Appeal judgment, that Court of Appeal judgment is the law and nothing but the law.
Now, furthermore, with regards to the Court of Appeal judgment and also the judgment of Justice Omotosho, now you recall that when Femi Falana was addressing the press after the withdrawal of that matter at the Supreme Court, his reason was that he was overtaken by events. And that is when he was referring to the 2024 appropriation bill, I mean the presentation of the 2024 appropriation bill to a four-man-led faction now assembly. Now, there were other reliefs that were sought in that particular judgment and was granted by the judge. Now, Femi Falana is premising the withdrawal of that matter on the 2024 budget alone. What of the other reliefs that were sought? Do you recall some of the reliefs that Justice Omotosho granted? Do you recall some of them?
Yeah, I may not have them handy here. Yes, I may not have them handy, but I know one of the reliefs sought is that the court should determine whether Martins is the Speaker of the House of Assembly or not, which the court in its wisdom recognized. And another is that the court should order Rivers State government to pay all their entitlements and emoluments.
Yes.
Yeah, I think these are the two vital.
Another relief was that the Inspector General of Police should grant security to Martin Amaewhule. Another one was that the governor should not interfere in the legislative functions. Yes, and that the governor was mandated to present the 2024 budget to them. And another relief that I recall was that the screening
of the appointees, the legitimacy or otherwise of the appointees,
to be done by Martin Amaewhule. Now, these are the few reliefs that I can remember. Probably in subsequent conversations, I will bring up the CTC. I'll post the CTC copy on the screen so that people can see for themselves. Because whatever the conversation we are having is based on that Justice Omotosho's judgment, which the appeal court upheld, and probably also the CTC copy of the appeal court decision as well will be posted side by side. But then these are the reliefs so far, to a large extent that I can remember. The question is, the governor so far, one would say, has not been acting in accordance to the judgment of Justice Omotosho, correct? What is the implication of that? And then secondly, when Femi Falana said that, it was going to be that the appeal at Supreme Court was just a mere academic exercise because it was overtaken by time. Do you agree with that it has been overtaken by time?
No, with profound respect to our learned SAN, I disagree vehemently that infraction of the Constitution have been overtaken by event. No, that is a pure constitutional infraction. The Constitution stipulates what should be done and how a budget should be presented. Not just budget, other requests from government, how they can bring it to the House of Assembly and what the quorum should be. So, what the Rivers State government did, to me, is a constitutional infraction, and I know that one of the consequences of a governor who breaches the Constitution, or maybe breaches his oath of office, or commits acts unbecoming of that office, I know that one of the implications is impeachment. If the Rivers State House of Assembly deems it fit and, has proof that the governor actually infracted the Constitution, he can be impeached. That is the law. It's there in our Constitution. Things that can lead to the removal of a governor of a state. It is there in the Constitution. And believe me, presenting a budget to a 3-member House of Assembly, anybody who is justifying that is only trying to, speak the law from the wrong side. Because that section is clear and certain as to number of persons that can form a quorum of a House of Assembly before a governor can present budget. So our learned SN telling us that the action of the governor presenting budget to 3-member House of Assembly is right. I humbly disagree with him, and I think we should look at the laws of the land straight so that we don't misquote the law and set bad precedent that will haunt us for a very long time.
But then, moving forward, what do you think? Well, anyway, let me just read part of the judgment of Justice Omotosho, because I had to take my time to, dig the archives. Now, this is part of it. He said, an order of injunction. This was part of the prayers, an order of injunction restraining the 1st to 10th defendants, that is National Assembly, from entertaining any request from the 11th defendant, being Governor Siminalayi Fubara, to take over the performance of the functions of Rivers State, including its role to make laws for peace, order, and good governance of Rivers in respect of matters that are within its constitutional and legislative competence. In other words, they prayed the court to restrain the governor from inviting the National Assembly to take over the role of the Rivers State House of Assembly. Now, the second one was an order of mandatory injunction compelling the Inspector General of Police, whether by himself or by officers and men of the Nigerian police force under his command, to provide and continue to provide adequate security and protection for the first plaintiff under the leadership of the second plaintiff as the Speaker of the Rivers State House of Assembly for the purpose of transacting the business of the first plaintiff. Now, an order, the third one, an order restraining Fubara, including the 12th, 13th, and 14th defendants, from withholding any amount standing to the credit of Rivers Assembly in the state's consolidated revenue fund, including salaries and emoluments due and payable to the Speaker, Deputy Speaker, and other members of the House, as well as to the clerk, deputy clerk, and other members of staff of the Assembly. Right. Now, this is part of it, right? When Justice Omotosho was speaking, Justice Omotosho observed that Ehe, through his lawyer, Oluwole Aladedoye, has resigned from the Rivers State House of Assembly. Omotosho also said that Edis Nehe lacks the capacity to sue or to be sued in the case, as he's no longer the Speaker of the Assembly, right? And He said, again, that Omotosho disagreed with the plaintiffs on the powers of the governor, noting that the power to make laws in a state are shared between the executive, the state assembly, and local government areas. Now, and part of the things when he was speaking, he said that there is nothing before this court showing that the Rivers State House of Assembly is unable to carry out its functions. And he also spoke on the removal of the clerk. You recall that the clerk was removed during that crisis. He said on the removal of the clerk of the Rivers State House of Assembly, Emeka Amadi, who was redeployed by the Rivers State Head of Service, Omotosho declared that redeployment null and void and invalid in the position of the law. Now, a lot of things were said. A lot of things were, this is a very long read, but then I want you to react to the ones I have read out now before I also bring up the final ones.
Yes, like we reiterated before, the Rivers State governor have vehemently refused to execute the judgment beginning from the time the Federal High Court led by Omotosho gave that ruling. And everything read out there was exactly the pronouncement of Omotosho. Then on getting to Court of Appeal, the Court of Appeal upheld same. The Court of Appeal never invalidated any section. The Court of Appeal never invalidated any of the orders as prayed and as granted by the Federal High Court. What the Court of Appeal did was to uphold that judgment in its entirety. So what we are saying now is all the reliefs sought were granted by the court, but the state government have still not implemented any. It's very, very unlawful. It's very, very unlawful because it is unlawful to be law-abiding in a state of lawlessness.
Now, the interesting thing here is with regards to the withdrawal of the counter affidavit, the judge observed, or Judge Omotosho said that the governor's legal team had withdrawn all his processes in the matter, adding that it means that he admitted all the facts stated by the plaintiff.
That is it.
Interesting. Now, I want to ask a question because this is a question I've asked other guests, but I'll ask you before we move over to the next story. And that is the issue or the argument around post-defection, pre-defection in this matter. A lot of persons will say, I have had lawyers also tell me that the judgment of Justice Omotosho was a pre-defection matter, right? Now, this matter was instituted November 2023. Now, the alleged defection happened December 2023. And the judgment of Justice Omotosho came on the, I think, January 22nd, 2024. Can one say this is a pre-defection matter, considering that the alleged defection happened during the lifetime of this litigation?
Okay, we need to set the record straight for the purpose of the listening viewers. In law, time of judgment is never in essence.
Okay.
Because when a judgment comes, for example, you see most times land disputes may last in court for over 10 years. But finally, when that judgment comes, it becomes final. Does that mean because it was instituted 10 years ago, so now the judgment has come now and it can be effective? No. Like we have said, I am not I am not, subscribing to the fact that most people think it is pre-defection judgment or the judgment came post-defection time. I am not, in fact, I am not privy
to
all that. But what I know as a lawyer is that when a judgment comes, it stands. The only way that judgment can be invalidated is only when a higher court of record says otherwise. if a higher court of record dismisses any appeal or application affecting that judgment, it then means that judgment of the lower court is the law. So our learned SANs out there and our big seniors out there should please interpret the laws the way the courts have pronounced them, and let the common man comprehend succinctly what the pronouncements are. We know that we lawyers, we are trying to justify the fact that we can defend our clients very well, and also justify the fact that legal fees have been expended. You actually want to do your job. But it is also trite in law that lawyers shouldn't file frivolous applications. The courts have frowned against that on several occasions. And it is also trite that a lawyer, you need to be honest with your client. You tell the client, a client, briefs you to do a matter. You should be able to, okay, you take the brief, you tell the client when you get him back to him or her, and you advise accordingly, according to the spirit of the law. You tell the client, look, this is what the law says about this subject matter. In my advice, I am advising we do A, B, C. But if you insist, but you need to be honest with your client. It is even in our RPC. So I wonder how, most of our seniors are acting radically out there. It doesn't really show good examples to we that are learning from them.
Right.